Hey, what's good, everybody? Welcome back to the channel. This is Carl from Sovereign Citizen Chronicles. Today, we're going to be in the courtroom of Judge Phyllis Webster and also Judge Lee, both out of the state of Kansas. All right, they're going to be going up against a sovereign citizen who didn't have a license, but he thinks he doesn't need a license. So we're going to see how this is going to work out for him. All right. So the first case I've already posted on this channel, but being that this is three different cases, I said I'll put the first case in with this case, with the other two cases. All right. So it's going to be his very first appearance with Judge Phyllis Webster. Then his second two appearances is going to be with Judge Lee. All right. So let's get to these court proceedings.
We'll go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. And the defendant, Isaiah Curvin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is one count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Curvin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before that about the jurisdiction. I was challenging jurisdiction because I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that give the court two ways? Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime admiralty law? Which one am I want to be tried under with jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only two, and it has two criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Basically kind of more of a statutory violation this defendant, you know, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
because I'm just asking questions right now.
If he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Miss Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented 19 Canap 2nd 982, State of Kansas versus Gardner L. Jones III. Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that, because when you say that I consent, is there like a form? Would that what would that be under? That would be civil. Would
Sir,
that be like
you consented by your conduct of going onto a road that is a state of Kansas highway and a.
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you. and you got on the road and you consented to driving on the road, and therefore you did consent
I
to
understand that.
laws associated with driving. So I am going to hold you to the law in this
I understand that.
particular case. Now,
What I'm understanding when you say like when you said the cause of nature, and but that's why I was not understanding still about that because you said the cause of nature, and then I asked
sir, if you want
what
me to entertain any of your arguments, you need to have them well thought out, and you need to have them
that's
in
what happened.
writing, and
That's
you
what this
need to have them,
appearance is for.
sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and you just start saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So by now you should have had all your motions on file. We're ready.
Yeah, maybe misunderstood what I was
please
asking.
Don't interrupt to me.
I still had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. Because I was going to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What do you intend to be tried with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal, sir, there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath of office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now, that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, you said it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view? I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. It froze.
I don't know if my phone froze or your did.
Oh, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the Sixth Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under so I can rightfully That's like how to defend myself,
Okay,
ma'am.
you don't
And
like my
you don't,
ruling.
you don't. So I had to. So are you telling me I have to get a lawyer to understand? For the record, you just have to get a lawyer to find out what I'm going to be tried against? Is that just some type of secret jurisdiction that I shouldn't know
Okay,
about?
okay, sir, here's the deal. You're either, I'm not gonna play games with you.
I'm
I
not. I'm asking
understand,
because
I
I have the right to defend
understand the
myself.
sovereign citizen, uh, position that you
I'm
take,
not claiming. I didn't say anything
but
about sovereign anything, ma'am. I'm asking
you're
have the
sure
right to
making
defend
their
myself
arguments. You're sure making,
under my Sixth Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer, and I'm like before I even go to trial, I like to know what jurisdiction am I falling up under, and
I
you're telling me
told
I have
you,
to find in order to find out I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only some way only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment. Do
uh,
you not?
okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. I'm not
No,
going to
no,
keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party. So
Sir, quit repeating yourself.
if there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get
I'm
me to?
not arguing about the court. I'm trying to understand. I'm
If
trying to understand the whole.
I cannot educate you and train you
I'm not
on
asking for
law.
educate because
If you
you're
want to sir, do you know there's a person that's going to try to type out this transcript? And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question or the next point. You don't have any motions I can rule on because you don't have anything in the file. So
official.
are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try one, is there someone that was hurt to make a criminal matter? I like to know who it was.
Are you going to hire an attorney, apply for
I'm
court appointed, or continue to waive your right and represent yourself? Keeping in
representing myself
mind,
personally.
keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So what are you going to do on the issue of attorney? Continue to,
I'm just simply asking you to identify the code of the written law that you're asking to do. I'm just asking you to which code is that you're bringing against me as a constitutional law. Because if that's a
you're
civilized law,
taking up time. Can you not understand what I'm saying?
ask me if I want a lawyer. If I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, what if it makes a criminal matter? That means it has to be like some injured party. Where is the injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a
Before
Zoom.
we get to trial, I'm trying to figure out the jurisdiction. You said we want to know what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
I'm appearing in person right now. I'm doing my duty to appear, but you're not
We're
telling
not
me.
having a Zoom jury trial.
They're not telling me. You're not telling me you're not even telling me what the nature of the cause. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an injured party. I'm asking where's the injured party? Can you bring the injured party forward?
I am going to, Missy, do you know where Miss Gillette went?
I don't, Judge. I'm assuming she lost signal.
So, are you not going to tell me this what today? You do have the right to know.
You want to try
Excuse me,
to,
Your Honor.
do you want to try to see if you can find her for me, Missy?
I think when she gets signal, she'll be back.
Okay, well, we're going to be in recess till Miss Gillette gets her signal and gets back here, because I'm not going to do anything without both parties present. So we're going to go into recess.
Sorry, Judge, my phone screwed up.
Well, apparently the defendants did too, so I'm going to give him a few minutes to see if he comes back.
Everything went out and I couldn't get back on at all.
There he is. We are back on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case 2023 TR 300060, State of Kansas versus Isaiah S. Curvin. Parties as before. Mr. Curvin, you are set for jury trial.
But before we even get to
Wednesday.
trial, Matt, you still haven't answered my questions. But I still want to know
Wednesday,
the cause of nature
November.
of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we
All
get to jury
right,
trial. You're just
okay.
setting it.
You are now found in contempt.
That's it.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions
Ma'am,
about?
I don't. No, I still have questions that was never answered.
I'm not your attorney, sir. I'm your
Yeah, I
judge.
know you're not returning. I'm asking you, Judge. I'm asking for legal violation. Ask you what was your legal intent. You still haven't even told me what your legal intent. I asked you what was the nature and cause of this
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that? What was
The
your nature and cause?
nature of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
And you said this,
I'm not-
and I asked.
we're not doing this.
I said a question. So when I asked you what jurisdiction the court, the Constitution grants the courts the two jurisdictions, which one is common law and the other one is maritime admiralty law. You said it's neither one of them.
Sir, you better go back to law school because I don't think you got the education you need to represent yourself. You go back to law school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I asked you which law.
Sir, I am not
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
Okay, I'm gonna fine you. I'm only gonna fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me what.
I'm going to object. It's been asked and answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case. Where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench. Under the case law. So therefore the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case, Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we
don't waste a jury's time and have a bench trial on Wednesday. And move forward in the case.
Mr. Kervin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not going to prejudge, but Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have? Can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me
I
in.
think our 11 o'clock went off. Let me.
I was going to say
Are you saying I have to-
11 o'clock is the perfect time for the state judge.
Well, but I've got to
So you
give
said I have to be
Mr.
in court
Kervin,
tomorrow?
I've got to give, sir, please quit interrupting. This is not a free-for-all. Ms. Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here, or give him time for a plane ticket, or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot
present.
make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well,
You told me you said Wednesday at first, and now you're saying tomorrow.
well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I
most
could do the
cases,
Zoom, but I wasn't able to drive because this like where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like, or like probably 2, and I would like drive like just like 32, 14. That's like half a day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like
if you don't have
I
a
wouldn't.
license, you better not be driving, because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then most likely a warrant would issue for your arrest, and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas, you violated the laws allegedly in Kansas, and you've taken up a lot of the court and counsel's time. So,
Well, I was told the officer said he told me I can take care of it from Texas. I would have to come back to Kansas when I got the rest of the
I have always told you that the trial would be live. Don't be pulling that on me.
No, not you. I'm talking about the officer when I got the ticket when I first got it. I let him know like I was just coming through Kansas. Like you don't live here. He said she said normally it's stupid do videos and stuff because it's like different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Miss Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Kervin,
say it again, ma'am.
any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on file, and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
I have a question
Judge.
before we go. When you said like how to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email to I sent it a few times. Not like that was the only way.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can apply,
they told me,
and I will appoint one.
They told me they had received them before. That's why I was understanding. Like you say you never received them, but you say you received them before. Like the first time we appeared, and then I haven't received them. I haven't called.
Just because you keep repeating something doesn't mean you're going to get a different result.
No, no, I have an opinion. I'm asking, like, they never received it, but they told me they did. That's just
You
kind
keep
of
saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
okay. You have a good day, Your Honor.
Thank you, sir. We are adjourned.
All right, the next matter is State versus Isaiah Curvin, 24 TR 17. There's the name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem. Yeah.
Thank you. All right, this is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, where if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court-appointed counsel. We'll take that up as go further. Additionally, at a trial, you would have the right to be presumed not guilty. The state would have the burden of proof of beyond a reasonable doubt. You would have the right to cross-examine the state's witnesses. You have the right to call witnesses on your own behalf and to utilize the court subpoena power to make sure they attend. Additionally, you would have the right to testify or not testify as you see fit. If you chose not to testify, that could not be used against you in determining if you're guilty or not guilty. You understand your rights, sir?
I do. Yes, sir.
Right. In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Oh, well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under maritime law?
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to
I heard
repeat
part of
for you?
what you said. So
Okay. I was saying, for the record, I did not simply understand nature and cause of action being brought against me, with regards of the elements of our persona jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime law. So I can know how to defend myself, and then I can enter my plea.
have you filed a motion for discovery in this case?
I filed in my I put a special appearance and affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the special appearance. Did you receive it?
There is a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature. It says respondent beneficiary of the named defendant in constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because it's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a one-page document.
There's only one. It's supposed to be more. I faxed the more over there. It was supposed to be like 4 pages.
It's one page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action being brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
because my special appearance didn't make it. I need to resend that as well. How can I reset it so I can have a chance to resend my special appearance because it didn't make it into. I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? Have time to do that? I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. I'm going to set aside 2 hours for a bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. That'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the 17th.
An hour.
That's about 1 hour. Okay.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there like maybe like the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st at 9 a.m.
Okay.
So May 1st at 9 a.m. That will be in person at the Elk County Courthouse in Howard, Kansas. You'll need to appear at that time. You'll need to have your pretrial motions filed, including your request for a jury trial. At that time, if everything's in order, we'll set a trial. Counsel, anything further?
Not on Mr. Curvin, Judge.
Mr. Curvin, anything further today?
No, Judge.
Very well. With that, we are adjourned. State of Kansas versus Isaiah Curvin, 24 TR 17. Would counsel state their appearances, please?
I'm here, Your Honor.
May it please the court, the state appears by Jill Gillette County.
And you're Isaiah Curvin, correct?
Correct. Yes, I'm here.
Thank you. All right, Mr. Curvin, there was an earlier date where you failed to appear. A warrant was issued. You were picked up on that. You posted bond. The court order was for you to appear at the sheriff's office, which you've done. So we'll move on. Today was set for a pretrial. At an earlier hearing, you had pled not guilty, or plea of not guilty had been entered on your behalf. I have reviewed the file. There was a document entitled Notice of Special Appearance by Affidavit. Mr. Curvin, did you file that?
Yes, sir.
All right. I have reviewed that. Ms. Gillette, do you wish to make a comment on it before I rule?
I do not, Your Honor.
Very well. Mr. Curvin, is there any brief statement that you want to make in support of your motion?
Oh, well, I want to ask a couple of questions before we get on to anything.
You can start.
Okay. Yes, I want to know what I'm going to be tried, jurisdiction I'm going to be tried under. Is it going to be civil or is it criminal?
I think we went through this before, and you're charged in the state of Kansas, and this is the Elk County District Court.
Okay.
So you are charged with operating a motor vehicle without a valid license. That is a Class B non-person misdemeanor, punishable up to 6 months in the county jail and a fine not to exceed $1,000.
Yes, I still don't understand it. I don't understand. Is that a criminal or is that a civil? Like, is that a criminal?
Well, Mr. Curvin, I've seen these motions before. I think you well understand where you're charged and what you're charged with. So let's not fool each other here or play games, please.
No, I'm not playing any games. This so I can properly defend myself because criminal and the civil, there are two different ways of doing things. In order to properly defend myself, all I have to know which one am I going to be tried against.
You are charged in a traffic matter that is treated as a criminal. You would have the right, all the same rights that I mentioned earlier when I went through the rights. You would have the right to a trial by jury or court if you make the timely and appropriate motion in writing. for the jury. Otherwise, it would be a bench trial. The duty would be on the state to prove you guilty beyond a reasonable doubt.
Okay. And you said it would be a criminal matter, you said?
I mentioned that already, how it's treated. It's a traffic case.
Okay, that's what I was asking, just to verify. So if it's criminal, if it's under the criminal, then it has the court grants this under Article 6 to jurisdiction under the criminal matter.
Okay, Mr. Kervin, I have read through your motion. I disagree with your assertions of the law. Your motion is denied. We will set this matter for trial. Are you going to be representing yourself, or are you going to hire an attorney?
Well, before I go to trial, I have to know what's some questions I really have to have answered before I can enter anything, so I can properly defend myself.
I've answered the questions that are appropriate. Now, your motion and the things that you have in there, again, they're not accurate statements of law in regards to these type of proceedings. Your motion is denied. So we're going to set this matter for trial.
Okay.
I need to know if you are going to be represented yourself, or are you going to be hiring an attorney?
Can I ask what is the reason for my motion to be denied?
I've already ruled on it. It's not applicable law to this case. So, and your assertions of what the law is are inaccurate to a large degree. So
yeah,
I'm not going to go through line by line to do that.
No, I'm just trying to see to understand which ones you're referring to, so I can understand what was wrong, so I can know which one you're stating that's inaccurate, so I can have an understanding.
All right. So my question is, are you going to represent yourself, or are you going to hire an attorney?
Well, before we get to that, I have to know how to defend myself.
All right. We're going through this cycle here, and I'm not going to play the game.
No, I'm not.
Sir, be quiet.
Hmm.
You're here for a pretrial where you're not being responsive to my questions. If you want to have an attorney, you have the right to have an attorney. If you wish to be represented by counsel and if there's any risk to jail, typically there are times where there is a jail sentence that gets attached to this charge. You can apply to the court. If you meet the criteria, I'd appoint an attorney to represent you. Like I told the gentleman before you, that doesn't mean that you're going to be free. You also have a right to represent yourself. Those are the choices that you have. So you can hire an attorney, you can apply for one, or you can represent yourself. It's one of those three. Which one are you going to do?
Well, from my understanding, once jurisdiction is challenged, it's on to the plaintiff to prove the jurisdiction on the record.
That's at a trial. One of the issues that the state would have the burden of proving is that this occurred in this jurisdiction, which is Elk County, Kansas. That's a question of fact for the trier of fact.
But isn't it jurisdiction can be challenged at any time?
All right. I'm going to find that you're waiving your right to an attorney. I have requested you to answer that question numerous times. I'm going to set this. Stop interrupting. I'm going to set this matter for trial.
Before you do that, I still have I haven't answered my question. I'm trying to understand to come to a conclusion to see how I'm going to handle my case.
All right.
I'm still
you have been asking questions that are not relevant to these proceedings, and I think you're aware of that. I've seen these motions before. I've seen the people try to do exactly what you're trying to do now, where you're not going to piecemeal this out. I've answered your questions, and I'm setting this matter for trial. That would be in person at the Elk County Courthouse. Sarah, we need to have a 2-hour stop talking.
Mm-hmm.
We need to have a 2-hour setting.
Can you correctly reflect that this court plans to bring a case against me, which it does not, will not let me know what I'm going to be facing against? Because I'm just asking a question to get a proper understanding what's going against me. Because I'm not understanding the jurisdiction of this, which jurisdiction I'm going to be tried under. That's all I'm asking, just to get some type of clarification. That's it. I'm not playing the games. This is a serious matter. This is a court date. I came all this way to understand, to see, how it's going, to properly defend myself. I'm not trying to waste your time.
Not going to argue with you about.
No, I'm not here to argue either, Arne. I'm listening to what you're saying. I don't want to, I heard everything. It just like, I want to understand what's going on. And like, if it's like, how does the trial work if I
You
don't?
need to be quiet now. Sarah,
I have one question. Like,
Sarah, no. Mr. Kervin, I told you need to be quiet now. Sarah, do you have a date for trial, please?
I have a question. If I don't want to do a trial, what's the other option that you
Okay,
have?
Mr. Kervin, I'm waiting for the clerk to give us a court date, please.
Yeah, that's fine.
Nothing further.
I'm asking. You need to. Because.
Mr. Kervin, if I have to tell you one more time, you need to be quiet. I'm going to find you in contempt.
Yes, Judge, we can do the morning of October 28th at 10 a.m.
October 28th at 10.
Yes, sir.
Okay, our trial will be October the 28th at 10 a.m. That will be at the Elk County Courthouse. Mr. Kervin, as I've explained to you, you have the right to be represented by an attorney. That is, if you wish to ask them questions, obviously that's appropriate to do. If you're going to represent yourself, we're going to be going with what the rules are here in Kansas, not something that you've read online or in line with what you filed. So if I strongly represent or indicate that people are better off being represented by counsel, but that's your choice. But you understand what the potential penalties are. And if you're representing yourself, you're going to be held to the same standard as an attorney in regards to being responsive and how you conduct yourself and how you present your case.
Well, I was asking about my fines. If I want to not do the trial thing, how was a fine, or does it have to be set for a trial in order? Like, that's what I'm asking.
All right. If you're wanting to plead guilty, you can. If you want to plead no contest, where you're not pleading guilty, where you're not admitting to it, but you're also not challenging what the state has done, you have the right to do that as well.
Yeah, that's why I was saying I wasn't challenged. I was just trying to understand. So how much is the fees or whatever once that's settled, would that take care of everything? And I'll need to know like the amounts for whatever it is.
Well, I have told you what the maximum penalties are. I don't negotiate with people. I don't tell them what the sentence is in advance. I'm required to tell people what the maximum penalties are.
Okay, so you said the penalty was jail time, but you didn't say the cost.
I said that I said that on a Class B misdemeanor, which this is, the punishment is up to 6 months in the county jail and a fine not to exceed $1,000. Court costs on this type of case are $108. There can be other things that are assessed as well. If a person was taken into custody, generally there's a processing fee of $45. Additionally, if somebody is found guilty, if they're placed on probation, there's a fee that goes along with that. There's various things that occur with that. But as far as the penalty section, I've advised you what the maximum penalties are.
Okay, so for the fees will be like you said like 1,000 and then about 40, so like about almost
I said that the maximum penalty is 6 months in the county jail and a fine not to exceed $1,000.
Okay, so do you have a number for me so I can see if I'm able to pay to see how much I would if I can even.
Okay, Mr. Kervin, what you're doing is asking me to give the sentence before you pled guilty. We don't do that. I've explained that.
If I do the no contents is what so I'm not arguing with you, I'm just if you said no contents is not an argument. So if I do no contents, what am I looking towards?
No contest. It's the same penalty. A no contest, you're not challenging what happened. What happens then is we ask for the state to proffer what their evidence would be. That means they make a statement to the court. If the factual basis that they recite, if that was their evidence at trial, then a person is found guilty. It's not a situation where you get to contest that. If you're wanting to contest what the charge is, that's what a trial is.
Okay, yeah, that's why if I want to do the no contents, I want to see what the state would have to say. That's what I'm trying to see if we can take care of this and resolve this, because I'm not arguing with the courts.
All right. Have you been in contact with the county attorney's office prior to the court proceeding?
No, just today, just right now. I believe I sent a copy of my documents, but I haven't spoke to them anything about anything else.
All right. The court is not a part of any negotiations that can occur between the person charged and the county attorney's office. Ms. Gillette, are you willing to speak with him if I call a brief recess?
Sure.
I didn't hear your response, Ms. Gillette.
Sure. Yes. Sure.
Okay, Mr. Kervin, if you want to speak with the county attorney about what her recommendations would be, I'm going to do what they call a breakout. And so we'll be putting this case on pause. On the screen, it'll ask for the person to click it for the breakout room. Then that's basically a private conversation with whoever's there in the room with you and the county attorney. It's not being broadcast out. It's not something that I hear. So I'll grant a brief continuance. We'll be in recess for that. And if the clerk would do the breakout room, please.
Okay.
All right. Record will reflect that both the record will reflect that both the defendant and the state have returned from the breakout room. So we have the same appearances as before. Mr. Kervin, did you get an opportunity to speak with Ms. Gillette?
Yes, we spoke, and I believe we came up to an agreement.
All right. Ms. Gillette, is that correct?
Yes, Your Honor.
And what's the agreement as you understand it?
He's going to plead no contest to driving without a driver's license. And my recommendations are going to be a $100 fine, court costs, no jail sentence, pay in 60 days. And that if he doesn't pay, his license would be suspended. He does have a cash bond that he paid cash. He would consent to any fines and costs being taken from his cash bond. There's a form he'll need to sign at the county district court office over here, and then any difference would be refunded to him. So he does have the money here, and it will be paid out of the cash bond he has on file. I did look up; I believe it is a cash bond, and the difference would be refunded to him. Those are going to be my recommendations.
Okay, so you're recommending a $100 fine and court costs. Is that correct?
Correct, Your Honor.
All right, Mr. Kervin, is that your understanding of the agreement?
Yes, sir.
Okay, Mr. Kervin, you need to understand, like I mentioned before, the court is not part of the plea negotiation process. So I'm not bound to follow the recommendations that the parties make, even when they've agreed to it. The court could sentence you to the maximum that I told you. I'm not saying that's what I'm going to do, but you need to understand that legally is possible.
Yes, sir.
Okay. With that in mind, is that correct? You still wish to proceed with a no contest plea?
Correct.
All right. Do you understand that with a no contest plea, you'd be waiving your right to a trial?
Correct.
And has anybody forced or coerced you in some fashion to make this decision?
No, sir.
Very well. Ms. Gillette, what would the state's evidence be if this matter were tried?
Yeah, the defendant was driving home from Greenwood County. He had a case up there, and as he was driving home, he was stopped here in Elk County. They did not know that he had been in court up at Greenwood. By Deputy Mike Nelson on February 6, 24 at 3:30 p.m. on Highway 160 and 99 junction. He was driving 2007 BMW. with a Texas plate. He had no driver's license. I don't know if he just hasn't renewed it and it's expired. Oh yeah, I do. It was expired. And he has not renewed his license. So his license is considered expired. So he had no DL, and we charged him under 8-235.
All right. I do find that there has been a factual basis that support the charge. And I do find the defendant guilty on his no contest plea. We'll proceed at this time to sentencing. Does the state have any additional statements that you wish to make?
No, Judge, just the fine court cost and apply his bond and refund the difference.
All right. Mr. Kervin, are there any statements you'd like to make before I pronounce sentence?
No, sir.
Okay, Mr. Kervin, do you have your driver's license now?
It's just an occupational license that I used to go back and forth from work, but not an actual license. It's just like kind of like a work permit type of thing. And but I'm not driving. I came here with my family member to bring me here to come to this court.
Okay. I'm not familiar with, is it Coolidge, Texas that you live?
Yeah, I'm in San Antonio now, but that's where I was staying at before.
Okay. All right. Texas requires a driver's license. In Kansas and Texas are a lot like each other in the sense that most people to get to and from work and so forth need to be able to drive. I strongly encourage you to get a proper driver's license. I'm going to pronounce sentence now. I'm going to impose a $100 fine, and I'm going to assess court costs in the amount of $108, which is the statutory amount. I've considered giving you a jail sentence. I'm declining to do so. So there's not a jail sentence imposed. However, I am going to require that this be paid. And you have cash bond that's here in Elk County, or did you post that down in San Antonio?
It was Republic. It's in Kansas where I got picked up. I think it's Republic County or something where I bailed out there.
Let me check with the clerk in a minute and see if they've got that transferred up here now. Sarah, can you answer, is there a cash bond on hand for Mr. Kervin?
Yes, sir. We do have a cash bond posted for him.
And is it in excess of $208?
Yes, sir. It was 2,500.
All right. Okay, so Mr. Kervin, following this hearing, I'm going to order that you pay that today. You have the cash bond on hand. You can come over to the clerk of the district court. They've got some paperwork for you to do in regards to that. So you'll be paying the $208. They'll be refunding the other funds to you, and that will complete this case. Again, I strongly encourage you to get a driver's license. You're a young man still. I'm sure you're going to need one for work and various things. And the vehicle apparently was properly tagged. This isn't a case where a lot of times some of these things we don't have a tag and there's no insurance, and you're not charged with those. So I'm assuming you had those things. But you can really get yourself in a bind if you keep accumulating these type of charges. And most states will generate a license for you and then suspend it, and in Kansas, I can't speak for Texas, but in Kansas, there's some mandatory jail time on driving while suspended. So, for your benefit, I'd strongly encourage you to get a valid driver's license. This matter is adjourned and the parties are free to go. Thank you.
All right, y'all. So that's the end of those proceedings. Isaiah Kervin, he got off with a slap on the wrist. He's just going to have to pay some fines and some penalties. Hopefully he gets his license, as Judge Lee encouraged him to do. But that's yet to be seen. Hopefully we don't see him again as a sovereign citizen on the Zoom, in front of another judge. All right. On that note, if you're not a subscriber, please consider subscribing to the channel. Also, smash that thumbs up and leave a comment. And also hit that notification bell so you get notified when I upload more videos. All right. So this is Carl from Sovereign Citizen Chronicles. I catch you on the next court case. God bless. Peace.